Welcome everyone. Today we have the honour and privilege to be joined by William or Bill Bierce, who is the managing attorney and co-founder of Bierce Kenerson Attorneys. And it's a real pleasure because for many reasons. First, I realise many of you are consultants and are interested in growth and exit. And certainly when you get to the exit, there are many things that I have learned talking to Bill, but also reading his fantastic book. If you haven't found it yet, it educated me, and I've been involved in this for a long time. So welcome, Bill.
Thank you. Thank you, Joe. Great to be with you.
Now, I'd love if you don't mind to start with the book. So in writing my book, I realized my limits, and you probably can't see the number of folded down pages on this, but it's a really well written, accessible book for a layperson like myself to understand some of the complexities that businesses can face when they're preparing for exit or equity events, or really just dealing with partners. So I was hoping you could give me a bit of background about the story that prompted you to write it.
Well, this is I never really wanted to set out to write a book.
Okay.
I had too many situations with clients where I was resolving the same kind of issues with people who hadn't planned on an exit, and they didn't know what they were doing. And suddenly the exit was upon them. And suddenly it was a catastrophe and a crisis. And I'm saying to myself, this could have been planned. This could have been resolved. And so it was a question of studying behaviors and learning from the behaviors of people who have been trying to resolve issues either amicably or with hostile intent because they think they're going to get a better deal, or because they're special and they can get a special arrangement. And I saw all sorts of guys who were working together for the common good, but then discovering that things weren't right, that there was a disharmony, that there was expectations of exits in the future. One wants there's a timing disparity. One wants it now, one wants it later, and or there's a valuation issue. There's even events of trying to get shares that you didn't have originally, and you make a claim so that you can negotiate and quote settle the dispute and get shares. And you beat the tax routine for distribution of a receipt of ordinary income. You try to convert it to capital gains. I've done all sorts of disputes. So when I started writing this, I started thinking about what my issues were, and I was looking at the things from the beginning and from the end and in the middle. And my practice in law is basically international, corporate, commercial, technology, and employment. I help businesses globalize and localize. And so I have to think about ownership and strategies for there. So my problem was, how do we get people to exit jointly where they all maximize profit? And that's the purpose of the book, and to let people start thinking about this as part of their courtship with partners.
Yep. And I think that's a really nice way of putting it, especially the courtship bit, because in my experience, and I've done it personally, I'm guilty, it's very easy early on to say, let's leave all the legal stuff till later. You know, we've got enough on our plate. And you very clearly show in the book the dangers of just assuming a mutual understanding. And I've seen it sort of, and you will have seen it more than I have at the other end, where people have assumed things of each other, and those expectations are mismatched because they haven't been clear early on.
Yeah, I think people don't want to get into the legal part, but actually there's a huge amount of learning about partnering. And one of my biggest issues in life is governance and relationship management and partnering, and achieving mutual results, narrowing the scope of what you want to achieve together, and having a plan together as to what we're going to get out of here in 10 years, okay, or 5 years, or 20 years, whatever. And we're going to sell out when we get to a certain point, because we will have exhausted our resources and our opportunities, and it's time to go on to something new as a serial venture, serial entrepreneurs. And so the issue is, at each stage, just think about what you're doing and learn how to plan. And also, it's like you have to remember that all your deals in consulting and in closely held business, it's closely held, which means you have the mom and pop fights internally. And it's not public, and you don't have to disclose this, but you still have to have the conversations.
Yeah. Yes, and so after reading, so one of the companies I own or run is, I've got 2 other partners, and after reading your book, I went straight to them and said, okay, we thought we'd sorted governance, but actually it's a lot more complex than you thought. And so we've now, thanks to you, we've now got a set of documents, and having those conversations was so necessary, because, you know, things that you take for granted, you know, that you're not going to die, that one of you, you know, that you're all going to pull your own weight, and that, you know, no significant life events are going to change the partnership. All of those things can't be taken for granted, obviously. And I guess in some ways, you're like a surgeon in many ways, in that, you know, people walk around assuming full health and continued health, but you see it, you know, when it goes wrong, I guess.
Well, I see it at the beginning, and I've seen recently, I've had a case where 3 people got together. It was originally 50-50, then it was 45-10, and the 10 ganged up with one of the 45s to oust one of the other 45s.
Wow.
And the issue was they had discussed the concept of vesting, which is you're not going to earn your 40, you're not going to own all your 45, because you haven't done all the work to get us to the point where we can sell out the company. And if I did need to replace you, Mr. 45, I'm going to have to take some of your shares and give them to a replacement co-founder, surrogate co-founder, and entice them to come in on the equity basis there, give incentive compensation. So the vesting delays the ownership, and there are different structures in the law to do this, but I don't want to go into that right now.
Sure.
So the first issue is, are you fully vested at the beginning? And if so, why? And what are your assumptions? And can the corporation or the entity recapture your shares at par value, which is sort of nothing, in case you don't do a good job, or you leave, you retire, you whatever. So there's good leavers and bad leavers, and there are people who leave because they can't help it. So that's the first issue. And once you get over that issue, then the issue is, well, how do we keep? We're working for the enterprise to grow and succeed, because that's really what you want. It's like your baby. And very similar. Corporate divorce and family divorce are not so dissimilar. Okay. Because you have a baby, you need to share the baby, but you don't want to take advantage of the baby either. So vesting, then making sure that the corporation has the entity has the right to survive, and so it has all the intellectual property it needs assigned by you in consideration of your shares. And that you're not going to compete with it, and that you're going to have a decent exit strategy. And sometimes, you want to buy out a partner and you want to pay him a full price, but or her, but you gotta think about what's a way to do it that's financially feasible. So in a sense, the buyout needs to put the bought out partner at risk for a little while, because everybody wants to see the organization succeed, And if the organization, if he pays out all the cash and there's nothing left, well, then that's a failure of of a resolution. So there's balancing of risk in any exit, which is an agreed exit. And there are also ways to basically keep everybody on track. And that's the goal. Is smarter business exits requires a smarter exit intelligence, business exit intelligence. And so it's both emotional, and it's where do you feel, where the other people feel, where they're going. And that's part of your partnership.
Yeah, great. And certainly from a buyer's perspective, the less complexity involved in governance and ownership, the easier it is. They like simple stories and simple transactions.
Oh, well, listen, so now let's talk about the buyer's perspective. I love the buyer's perspective. So there are two types of buyers. One's a strategic buyer that will just wants to integrate a smoothly running machine into their operations. And the other is a financial buyer that can basically has on staff people who are going to restructure you, suck out all the information, and then fire a quarter of the people just because it's too expensive.
Okay, allegedly.
So in the strategic acquirer, they're looking for something which has in either case, you're looking for well-established business practices. And so I do a lot of work with technology, software development, software as a service, information platform as a service. Everything is now computerized. And so you start with a good business practice that's efficient and it's well written. It's enrolled in some kind of manual that you have. And so that's something which is a transmissible asset. It's called your intellectual property. And you develop that, and everyone contributes to it, and you have a team effort. That's great. But if you don't have a platform for that, you're just a bunch of independent solo practitioners running around. And I've seen in law firms, independent solo practitioners, they don't really help transmit anything, and all they're doing there is surviving. And that's not good if you're thinking about growing the firm or growing, transitioning to a next generation. And you should start thinking about this when you're 50s, so that you're not struggling when you're 60. So.
Yeah. Now listen, before we get on to some of the sort of details of the challenges and lessons that you've learned and things, I was wondering if you could tell us a bit about your law firm. So I specialize in consulting firms, and I understand them very well. And I know that culture and a unique value proposition is quite important. Is that the same in law firms? And if so, where does your firm sit there?
Well, product differentiation for law firms is based upon personality.
Okay.
Okay. And I think that the leader's personality, the founder's personality, is that of, in my situation, an international perspective and innovation. And it came to, I was lucky enough to study law in France for a year. And I was struggling because I was a foreigner. I was a minority. I was the only American in the law faculty, and I had to get by. So I made a lot of friends, and I learned a lot of things about I adapted. And so I learned culture. I compared my culture to others. In university, I studied the history of communism, the Soviet Union. I even studied the history of the UK. All right.
Oh, wow. Okay.
I know what 1066 does for you guys.
Yeah.
Okay. So it's really cultural awareness of where I think we're all focused on cultural awareness. I'm a member, and we're members of international bar associations, and we know a lot of people in different countries, so we do comparative law, and we respect the fact that a lot of other people have to speak a foreign language when we don't. We just take it calmly. So that's the international culture. Then there's the issue of innovation. And my first real client was a young fellow who was a 1/3 owner and of a software development company. And he was being asked to give a personal guarantee to a bank loan when the company was going south. And I said, no, don't do it. So with that, I went into both corporate and divorce, and I got into technology. And I've been basically thinking, what are the algorithms? What are we learning? How can we improve them? And it's taken me all the way from plain software development to artificial intelligence and machine learning.
Listen,
Okay.
just to interrupt there, I'm reading a great book that you'll really like. In fact, you may have already read it. It's called The Future of the Professions. Highly recommend it. And it covers, a lot of this stuff in all the professions, but especially law and consulting.
Well, in law and consulting, things that are generic tasks can be done by robots. So the value that you have is identifying what the robot screwed up on.
Yep.
And giving advice so they don't get there. And I've seen situations now where people are in corporate divorce because they took the off-the-shelf thing and they got real cheap and they have no clue what they missed.
Okay.
So it's cheap for a reason.
Sure.
But anyway, so then the supporting, I've been focused on treaties, globalization, and localization and national interests, police powers and protections and regulations and compliance. So I have a combination of comparative law and intellectual property, employment, and corporate governance across borders.
That's quite a wide. Did you start off quite focused and then build up that diversity?
Yeah. So I got kicked into it.
Okay.
So I was an associate at a 60 lawyer firm. I said, I need help on this lease for a commercial client. And the head of the real estate department says, oh, we're too busy with big clients. So yours a small client. Look, I'll give you a form, you can figure it out. So what I learned was I need a form, I can figure it out, I can handle it.
Okay.
And I'm in a life of learning. And it's not that I'm expecting to be great at it. I'm not an expert in every aspect of everything. So I know what I try to identify what I don't know and get a partner or a inside or outside to assist in those things which are outside my jurisdiction. I can't practice law outside of certain places, or outside my ken.
Okay. Now, on that note, in the book you mentioned Delaware a lot. Is that now? I know there's significant tax advantages to operating in some U.S. states and cities. Is that why it's mentioned a fair bit, or is that a specialist type of law?
Delaware is the de facto American corporate law.
Okay.
Because it's what you would expect of something normal and fair and equitable with a court of chancery. Not every state has a court of chancery for resolving disputes among shareholders and other rights holders in corporations. Delaware has a court of chancery, and they're very good. So these people, these judges know their stuff. Yep. They focus on that law. So it's like having a commercial division in a general court, but it's a corporate division. So that's for the adjudication, and for the corporation rights, they allocate rights and responsibilities in a fair way. They're predictable. They provide a lot of flexibility, and they don't give, like California, special dispensation to local resident shareholders. If you're in California, if you wanted to do a dissolution or something, the corporation has to explain to the shareholder exactly how he can defeat the operation.
Okay, right. Okay. So there's a few sort of details that I want to dive into that I've come across a few times. But before we do that, if you had I'm thinking about a standard client of mine, sort of, maybe 2 or 3 partners, maybe been going for 5 years. they maybe they've got their articles of association or whatever, the formal documents. They probably don't have a governance agreement or a partnership agreement. They've got a mutual understanding, perhaps. What are the 2 or 3 bits of things that you would say, you guys need to get on this sooner rather than later?
Well, so first one is veto rights. The second one is force majeure.
Okay.
And the veto right means that if it's proposed that they take action which you just can't stand, then you can either veto it or you can quit. And then if you quit, then the issue is how do you get bought out? What's the value of your assets? Is it valuable at all? Is there something left behind? What to do? And the second issue is in the force majeure, where I might become incapacitated for 6 months. I may need a cure. I may have COVID for 3 to 6 months or something like that. What we have there is, you can't predict everything. You can't control everything, but you need to think about what happens in an emergency. And those are the minimums, just the minimums.
Okay,
so
that itself is really useful advice. I know that some of the listeners will definitely take action after that. Okay, so I wanted to go into a few more challenges. Something that stood out that I hadn't paid much attention to personally are the different ways minority shareholders can be categorized, different powers they can have depending how you frame them. Could you explain why that's important?
Well, so the minority shareholder, the minority has a minority vote and minority ownership and minority control. And the normal rule in Delaware and everywhere else is majority rules. And there are certain things that you want to avoid having the minority control. The majority, a small majority. If you're having a large majority, 2/3, it used to be, it's funny, in New York state law, it used to be that 2/3 of shareholder approval was required for a merger. Okay. And now it's just 51%.
Wow. Okay.
Okay. So if you're a 45% shareholder, it makes a difference whether it's 2/3 or majority.
Yeah. So
you might say we need 2/3, or even in some cases 80%. For actually 80% is useful for tax purposes because that does tax-free reorganizations and things. So if you get to the percentage in which the minority can veto or control and refuse, so that forces the majority to concentrate on what's achievable and what's reasonable. And for merger, if you're going to be merging your entity, you want a little bit more than 51%.
Okay.
I think that because otherwise you're going to have people, and if you don't, who are in the minority and they may oppose it, and then they will try to defeat it, and that could reduce value for everybody.
Yeah. I guess if that the law provides a framework, but if you've got personalities that are intent on causing trouble, then you've got a big problem on your hands.
Well,
regardless,
we never have egos, do we?
No, especially in consulting, we never get egos in consulting. Okay, and how does that work? So when you're coming up to a sale, and you've got the majority shareholders in enough to take the decision. Let's say it's 2/3 in this situation. But you've got, and this is very common, you get 1 or 2 shareholders that either say it's the wrong time or it's not the right price. These are minority shareholders. Now, although they can't hold up the sale legally, any buyer is going to be aware of what damage they can do if they withdraw their labor or if they decide to leave, I guess.
So this is so what are you selling, and what is the asset being sold? You're selling bodies, and you're selling know-how and goodwill, customer relationships and continuity, and what I love is annuity revenue stream.
Yep, sure.
So now the strategy for the majority is to define annuity revenue stream to maximize. So we want to get the best clients that we can. So it's always the challenge to always target the ideal client. So it requires you to define who is the ideal client and what you want to sell to that. And then secondly, you want to have the assets on board that are in-house in your form collection. You know, I've got directories of clients, and we have a form file. And the form file is basically all those things that we stole out of some other deal. And then we looked at it and said, okay, it was close enough. We'll look at it as next time the possible form for us.
Yep.
And so that's part how you develop your assets. And then you also have the issue of the training of the juniors.
Okay.
Because the training of the juniors is essential, because that way there's a transition, there's the value. And that's something, training of juniors is for your own benefit, so that you don't have to do the work you don't want to do.
Sure. It's interesting how and in the book as well, your advice isn't just at the legal level. You also go into sort of, good practice around leverage and training and, all these other things. Is that something you advise on with your own clients, or is this stuff that you've just picked up over the years that you enjoy understanding?
Well, yeah, I mean, I have, yes. I look for systems. I look for compliance. I look for a group of people. All of this COVID thing has taught us about business continuity planning, disaster recovery, business resiliency, supply chain management, transparency, up and down multiple levels of the supply chain. And now law firms and consulting firms don't have a big supply chain, but they do have reliance on accounting firms, financial firms, banks, and others. So they want to know that they're dealing with people who will help the enterprise survive.
Sure.
And so yes, as a lawyer, I have to look at the gestalt, the whole enterprise, and feel that, I know who's in the HR department. I know who's in the IT department. I know who's in finance. And I asked them, what are you doing about this and that? And I'm not really acting as a consultant. I just want to make sure that I don't have a disaster tomorrow.
Yep. Okay. So listen, we covered a little bit of sort of the minority shareholders, and we covered a little bit of, some of the trouble that can be caused when by minority or others coming up to a sale. What are the other common challenges that you see when people come to you, perhaps approaching a sale or during a sale?
So in a sale, I have a questionnaire. And the questionnaire, if I'm the buyer, questionnaire is 15 pages of show me everything. Okay. And so as the seller, I'm saying, okay, are you ready to show them everything?
Yep.
And the everything goes to all the value of goes to the security of the value that's being purchased. And in the representations and warranties, you certify that all the disclosures are fair and true and accurate, and so that therefore the valuation can be approved. One of the big issues in an acquisition is surprises that cause material adverse effects.
Sure.
Okay, but that's sort of like the exception. That's the lawyer's game. It's the scenario risk analysis.
When you lift up the floorboards and find the rot, I guess.
Well, finding rot is if the seller knew that there was some rot, seller's got to take a hit. So in the M&A situation, there is the question of how much risk does each party take after the transaction. And there's usually a limitation of liability. There's a cap on liability for breach of warranties. And there may be multiple caps depending upon tax liability, unlimited, breach of warranties, limited, and a durational cap. So you have to discover the stuff within 6 months or a year or two. And then there's also the issue of whether the seller is going to be collaborating in the transition. And that depends upon whether there's an asset, if the seller is trying to retire or move on to something else or continue. So, the contracts basically have to cover all of the assets and the valuation issues.
Yeah.
And the valuation issues are, remember, there's comparables, and then there's a discounted cash flow. And it's not just the investment. The startups, forget about startups. They have like astronomical numbers for nothing. So what you're trying to do is you're trying to support the cash flow analysis that supports the purchase price.
And I guess one thing to emphasize here is also that, especially private equity buyers, they very often will have done this, 30, 100, 200 times. And so they're not stupid when they're making these deals. And it's quite a common, there's various tactics that they can use. And I think you mentioned a few of them in the book in order to minimize the price. And, something as obvious as just dragging out the due diligence process so that that the seller gets anxious and will sell at any price, or even setting targets for the earnout that are unrealistic, so they end up with a greater percentage. So it's something to be wary of, especially if you're completely new to selling a business.
How many people are selling a business? They're not experts at it.
Yeah.
Okay. So I think one of the things that I love about this plan for selling a business is if you plan 2 or 3 years ahead, you basically every month you test yourself against your targets. And your target is growth, stability, predictability, and focus on the right clientele. And so that you have something transmissible. Yep.
It's there's I can't remember the name of the document. My brain isn't what it used to be, but up on my website I've got a checklist of questions that people can be asking themselves. But I know in your book it's quite good because you've got a series of checklists that sellers can go through in order to make sure they're approaching the sale correctly. A confidential information memorandum is one of the things even though it's towards the end, is something I get my clients to look at quite early on in terms of the information that the buyer's going to need. Firstly, do you have it? But secondly, are you performing well and transparently on those criteria?
So actually, one of the biggest thing I think will create value for you on your exit, if you're going to sell, is that you have a plan, you've strategized for 2 or 3 years, you're consistent in your accounting process so that you can't be accused of accounting changes or a sloppy accounting. You've got growth, and you're growing into something new. It's like I might be growing into blockchain, because blockchain is something a few people understand and can provide tremendous trust and value. But there's a question of governance and control, because what if you need to change one iota in the blockchain? And who's got authority to do that? So it gets to governance asset management, resiliency, and cash flow. And each of these is these are not legal issues. These are business issues, which are essential.
And do you find that varies on the size of the firm? Do you find that different problems come to the fore with larger firms compared to smaller firms being bought? Or
Well, with smaller firms, I find that the founders have not done much to plan for their being replaced.
Yeah, sure.
And so there is a certain indispensability, and there's a refusal to share knowledge.
Yep.
Knowledge management is the biggest issue in this economy. Okay, if you have access to knowledge, you have access to sell and to buy and to evolve. And so with what I've seen in senior partner, they're not sharing, and they never did.
Yep.
So the issue for a viable organization, and frankly, if you're an equity shareholder in a partnership, you want to have everybody else contribute an asset of continuing value. And you'll agree to that, because you're not going to be working forever. You want to be able to go, I won't say play golf. You want to be able to do something different in your life at some point, or you may be prevented from doing something. So you need the formality of an asset. And anyway, I can't say how important it is to have that plan, to have it, to be ready. And if somebody wants to leave right away and they split off, okay, so you have a split off agreement. So you can adjust, but the question is, what do people keep, what do they take, and how they value it?
Sure, that's great advice. Thank you. And I guess something related to that is when, and it again, it's very common if that you start off a partnership, maybe you have 3 to 5 partners. And either through ill health or perhaps one of them gets a bit lazy, people start to, one partner isn't pulling their weight. Now, obviously some form of incentivization or renegotiation can take place there. But does that presuppose that you already have an agreement in place that if a partner isn't pulling their weight, that you can renegotiate these things?
Well, so how many partnerships are based upon a management committee that decides everybody's compensation every year? Okay, the management committee decides, and the partners don't decide. Management committee dictates, and one year you're up, one year you're down, and so the issues are: do you trust the management committee? Do you trust the process? And why should you? Okay. It's very difficult. And partners, I've seen partners who can't pull their weight for different reasons. I should tell you, I had that situation hit me. I had a client where I was under-diversified, and I had one client who's like 60% of my business. And they say, Bill, we love you. How would you like to be in-house counsel? I said, where? Illinois, Northern Illinois in the winter? My wife says, you can go, but don't count me. So I basically looked around, and I had to I helped hire my successor in the in-house person, and they built a little team around that person, fine. But I had to restructure. And so the issue is, what help will your partners give to you to restructure so that you can last more than a year or two and grow? And you're not going to be a burden on them. So you may take a cut in pay, and that's a lesson for diversification. You may want to spend some money on marketing and become really focus your efforts on your persona and your expertise and why you're the go-to person for a unique problem that's highly valuable. Okay, so you got to adapt. None of this is just planning. Disaster strikes, and so everybody has to be willing to adapt. That's my adaptation actually turned out to be the reason why I have my own firm.
Okay.
Because I was looking at at the structures that I would be committing to go into and the risks that I'd be taking and the assets that I could play with. And I was not in a strong position. So I was stronger on my own than staying put.
Okay, that's interesting. There's one well, probably not a final thing, but there's one thing I wanted to ask, and there's a wonderful section in your book, and you're going through the common triggers of crises, and you talk about the personality disorders of sinners from Dante's Inferno. I just wanted to know, out of incontinence, violence, fraud, and the others, a more serious question, what personality issue tends to ruin deals? I mean, is it because is it just bad luck, or is it generally someone trying to game the system or get more perhaps unfairly than they're due?
That's a great question. The issue is really not so much the individual, but the alignment and interaction of the individual with others.
Okay.
It's whether you have a community of like-minded people who are sharing core values. And because if you share core values, you can resolve things. That's what a marriage is about. And if you have someone who is, I actually have a situation where a female executive was a minority shareholder, and she wasn't getting what she wanted she was getting paid very well. She was in charge of everything, but she didn't like the CEO. She didn't like the chairman, who was majority owner, and basically thought that she wanted to get rid of him. And so she organized an employment attack. So this is in Dante's Inferno, the person who is at the worst, the ninth circle of hell, is the person who is in your family who's cheating you.
Sure. Yep.
Okay. So what she organized was she knew the chairman had a temper, and so she had a meeting with other people. She intentionally caused a row, made him pound his fist and yell and all sorts of stuff. She invited him. So then she said, she writes to me, "Oh, Bill, I'm scared. Well, now I've got a hostile workplace environment, in addition to a minority shareholder who's got breach of fiduciary duty claims."
Wow.
Okay, all orchestrated. So when you think about your personalities, identify whether the personality of person across the table is going to go crazy and ballistic like that. Now, what that did was it precipitated a sale of shares, which was fine. The problem is that exposed the chairman and the company to a high cost, higher because they'd have to pay off the alleged employment harassment and hostile workforce problem, which they could have gotten around if they just decided something else. But this is a personality schism, and she was in the family, and you talked. There's a mutineer in the family.
Okay. Wow. Wow. I mean, it's heartbreaking in some ways, isn't it? Because when you've built a company, or when you've actually got real family involved, it can, I've sadly seen a couple of situations where people are no longer talking to each other. I guess you see that a lot more than your average advisor.
Well, not talking to each other after they've been expelled, that's fine, because they've quit or so bought out, so that's okay. And I actually have a mediation bent. I'd like to, okay, as attorney for the corporation, for the entity, I want people to support the entity, because if they don't, they all lose. And so my goal is to accommodate where reasonable and to show value. And maybe there's a way, if you don't like people and you say, I can't work with you anymore, let's find a solution where we sell out. I had a case where there was a 50-50, and one of the 50s borrowed $500,000 for the company without approval of the other. just took the money out.
Wow.
And so the question is, what are you going to do with a guy like that? That's criminal fraud.
Yeah,
Okay,
yeah.
that's larceny. So rather than take the guy to put him in jail, we said, okay, how would you like to sell the company? You can sell it first. We'll give you 60 days. If you can't find anybody, we'll sell it, and you're gone, and we get priority. Because we, by the way, the other 50 had lent money to the company.
Okay, wow.
They should have taken 95% and let the other guy have 5, but no, that wasn't the deal.
Yeah. These percentages are difficult, though. I'm advising a firm at the moment, and they're going through fantastic growth. 3 partners. They set up together. The third one decided it wasn't for him and went off. They all put money into the company. He went off and did his thing. But since he left, the company's grown and grown and grown. But they never changed the shareholding. So this guy still gets 30% of something that's, 10 times the size of when he left it. And I won't go into the details of why they did, because, why they didn't have that conversation. But now they've got to have a much trickier conversation, which is obviously, how much do you need to give us the shares back?
Well, actually, this is an interesting question. On one hand, he's technically a shareholder and entitled. On the other hand, he's probably also a partner or a manager. And as a manager, he has a fiduciary duty not to be self-dealing. And if he's not contributing, then is he self-dealing? And I would argue, yeah, he's going off to do something different, which is taking away from value. And therefore, I'm going to hold you liable for self-dealing, and I'll pay you fair market value net after deduction.
Wow. Okay. See, this is why we like lawyers on our side. Wow. Okay. Well, you might be getting a phone call at some point from one of these. From one of these.
I'm just happy to help people get moving and move on.
I mean, it's interesting from a consulting perspective, because the value of a consultant is obviously that you see things dozens, if not hundreds of times, that most managers only see once or twice in their lifetime. But it's exactly the same with you. You see things day in, day out that, most buyers will actually never see, because, a lot of sales go through without any issues. It's a fascinating job.
Well, my goal is to respect everybody and to give them something fair. And I think that if you present it that way, things will work out well.
Okay, well, that's good, and I like the bit about personality and trust, and having that common value and culture. It's something that I always emphasize in terms of values, especially. It's better to recruit someone perhaps not quite as bright, but with the right values, than the other way around, and that's another good reason to emphasize that. Now, listen, I realize that that we haven't got a huge amount of time, but is there anything that we've missed a lot of things, but is there anything, important that we should cover before drawing this to a close?
The point of the book is basically start with the end in mind.
Okay.
And have business exit intelligence. And have a plan. It's a little bit more cost at the start to hire an attorney or any to plan and have some kind of protection for the enterprise. But if you want your asset to grow, you have to be willing to concede that the asset may be bigger than you, and at some point you may need to leave. But you want to do it on fair terms. And so that's really what's customary. Why are you doing this? What do you want? How long do you want it for? I mean, you're not going to be wanting to practice to be in consulting for 50 years, okay? Yep. Had enough of that somewhere.
Yeah.
And life expectancies go on. So basically, you need a toolkit for planning, for dispute resolution, and for governance. And governance, these public companies have governance rules. They set up all these structures and board resolutions and Securities and Exchange Commission requirements. And the purpose of that is to keep the enterprise going. And if you have good governance in many different ways, you have monthly board meetings, you have disclosures of problems and resolutions and accountability. All of these things are what create and maintain the trust. And I want to work with you again and continue. I'm very happy to work with you. We're a great team. You do this, I do that. We work together on projects and etc.
Well, I guess with your background, with your study of Soviet history, I guess the Americans always said, trust but verify, which could be a tagline for the book, couldn't it?
Well, you know about Stalin, huh?
Yeah, well, yeah. Yes.
Yeah, so it's a little bit more than that. I look at the Chinese system, and the Chinese have always had a centralized system. And so the issue is what level of disputes and what level of freedom to express and independence. And in a sense, they're very good at certain stuff that's repetitive. But what you want is people who are innovative, creative, and hard workers, and also team builders. And that's a really hard person to find. But I think with today's millennials, they want something, and they want that, and they want more. They want good works.
Yeah, definitely. I can really see it with my students. It's I always ask them every year. I ask, what percentage of you would leave a job because of bad work-life balance? And up until COVID, that percentage had increased every year. And I think it's a good thing. I think we've all seen people that spend their lives, 8 in the morning till 8 at night, and suffer the consequences. Well, listen, talking of overwork, listen, you also mentioned that you were very kindly going to put a chapter.
Oh yeah, okay. So let me share a screen here.
Yeah, you share the screen. So we're going to put this up on the we're going to put this up on the website. So that...
Okay, fine. So here we go. Okay, so I have restructured. I have 2 chapters of the book, which I made into separate books.
Brilliant.
There's like 30 pages each. Okay, there's nothing.
Great. Yeah.
And this is restructuring.
Great.
Which is one alternative, and then the other is international strategies.
Fantastic.
Here. Okay, so designing for sale from the beginning, and you have internet and international requires even more approach, good governance, and that's why you have separate entities where the entity itself is the structure for the governance, and you deal with the operations by cross-licensing, by service agreements and purchases and sales, which are all accounting and functional, but it's the governance the holding company, which defines where you're going together.
That's fantastic. Thank you so much, Bill. It's been a real pleasure talking to you, and I do recommend people to use this book because I fortunately found it before I finished writing my own book, and it meant that I could improve. Rather, let's not say correct. Let's say improve a lot of my legal understanding of the exceptions that to you wouldn't be exceptions. But when things do go wrong, if you're not prepared for them, it can be pretty terrible.
So Joe, just keep telling them to plan, and help them and ask them questions. And you'll, instead of being the guy on the left who's being expelled, you look at the people on the right who are going out as a team.
Brilliant. Okay, thank you, Bill.
Okay, thank you so much, Joe.
Good.
Okay.
Brilliant. Right. That was really good. I really enjoyed that.
It was great. Thank you.